inadequate compensation awarded by the tribunal. Full stop para. Parties shall be referred to as per their status. Please sit down. As per their status before the tribunal. The tribunal has awarded total compensation of rupees 10,70,004 rupees.
Out of that, which includes 95,000 towards the damages.
It's okay.
Otherwise, it is 9,75,000.
Including
95,000 damages.
Including rupees 95,000 as damages in the other connected matter in MVC number 687 of 2018. Along with 6% interest per annum, and directed the respondent number 2 insurance company to pay the compensation, to deposit the compensation within 30 days. Full stop. It is the vehement contention of learned counsel for the claimant that the tribunal has committed a gross error in not awarding suitable compensation and has misdirected itself in not taking into account the permanent physical disability of the left forearm, which is absolutely non-functional, and the claimant, being a farmer by an agriculturist by profession, would be unable to do his work in view of the crush injury suffered to the left forearm. It is further contended by learned counsel that the tribunal has committed an error in not assessing proper income of the claimant, and so also future prospect kottidara ilva. So also the tribunal has failed to award future prospects in the matter. It is also contended by learned counsel for the appellant that under other heads, tribunal has awarded meager compensation which calls for interference at the hands of this court by way of enhancement. Hence, he is before this court seeking enhancement. Accordingly, he seeks to allow the appeal. Full stop. Per contra, learned counsel representing respondent number 2 insurance company vehemently contends that the tribunal has awarded just and reasonable compensation by taking into account the materials placed on record, both oral and documentary, including the evidence of the doctor CW1. Hence, question of enhancement of income would not arise in the case. The tribunal has rightly assessed the disability, so also has correctly taken the income for awarding compensation. Hence, he seeks dismissal of the appeal. Para. I have heard a learned counsel for the claimant and learned counsel for the insurance company peruse the materials placed on record. Though it is disputed by the learned counsel for the insurance company, the occurrence of accident, involvement of the vehicle, injuries sustained by the claimant have been proved by production of exhibits P1 to P17. The doctor's evidence of CW1 and the records produced by the doctor at C1 to C13 also clearly exhibit the magnitude of the injuries suffered by the claimant. Under the circumstances, the negligence is rightly attributed against the which vehicle? Driver of the Swaraj Mazda mini bus.
Yes, ma'am.
Swaraj Mazda mini bus. Full stop. Para. Now coming to the aspect of age, avocation, income, disability and appropriate multiplier, it is seen that the claimant was aged 41 years as on date of occurrence of accident. The appropriate multiplier would be 14, which is correctly taken by the tribunal, and the same does not call for interference. However, the tribunal has assessed the income to be 8,000 per month, whereas the Legal Services Authority chart for the year 2017 prescribes 11,000 per month. And in view of there being no proof of income, the chart income has to be taken. Accordingly, 11,000 is taken as the income. Stop para. Doctor has been examined as CW1, was opined disability to an extent of 79.32% to the whole body. However, the tribunal, on consideration of the evidence of doctor, has arrived at a disability of 50%. Full stop. I'm in agreement with the learned counsel for the claimant that the disability assessed by the tribunal is on the lower side, without any proper basis or reasoning to reduce it from 79 to 30.32% to 50%. Full stop. But at the same time, the disability cannot be taken in its entirety as expressed by the doctor. As learned counsel for the insurance company contends that as per the schedule also, the disability for the loss of a forearm is 50%. But in the present case on hand, considering the fact that the claimant is a farmer and involved in agricultural work, his occupation revolves around the use of his both hands, and in view of the serious crush injuries amounting to non-functioning of the entire left hand, he will have to be awarded little more than the value prescribed in the schedule. Accordingly, this court deems it appropriate to award 60% towards functional disability. Full stop. In view of the above disability, the claimant would be entitled to future prospects at the rate of 25%. Therefore, the loss of future earning capacity due to disability would be 11,000 to 12,
25%, 2750.
11,000 plus 20%, 25%.
13 lakhs 86,000.
13,750, na?
13,750, 60% of that amount.
13,751 means 13,750 into 12 into 14 into 60%. 13 lakhs 86,000 would be 13 lakhs 86,000 as against 6,72,000. Full stop. Para. Towards pain and suffering, tribunal is awarded 50,000. This is ಇನ್ನೆಷ್ಟು increase ಮಾಡಬಹುದ್ರಿ pain and suffering?
25,000 maybe.
Another 25,000 is enhanced under this head. Towards medical expenses, tribunal is awarded 1,73,004 rupees. Same is retained. Towards future medical expenses, 10,000 is awarded. Same is retained. Towards food, nourishment, attendant charges, 6,000 is awarded. The same would have to be enhanced to 25,000, as the claimant was inpatient for 25 days. Towards loss of income during laid-up period, 24,000 is awarded. In view of this court, enhancing the income to 11,000 per month, taking a 4 months period for recuperation, 44,000 is awarded under this head. Towards loss of amenities, 40,000 is awarded. An additional 10,000 is awarded under this head. In all, the claimant would be entitled to total compensation.
17,63,004.
ಎಷ್ಟು?
17,63,004.
ಯಾವುದು? ಅದು ಆ್ಯಡ್ ಮಾಡೋಣ. 17,63,004.
Please.
17,63,004. Stop. The tribunal has decided the claim petition along with another claim petition filed by the claimant for damages of the bullock cart by awarding rupees 95,000. However, the same is not in challenge before this court. In view of the fact that a common judgment is passed, the said amount of 95,000 is retained. Under the circumstances, adding the said amount which is passed by virtue of a common judgment, the claimant would be entitled to total compensation of
18,58,004.
18 lakh
58,004.
18,58,004. ಇದರಲ್ಲಿ ನಿಮಗೆ ಎನ್ಹಾನ್ಸ್ ಕಾಂಪನ್ಸೇಷನ್ ಅದ್ರ ಬಿಟ್ಟಾಕ್ಬಿಟ್ಟು ಮಾಡ್ಬೇಕು. 95,000 ತೆಗೆದಾಕ್ಬಿಟ್ಟು ಮಾಡ್ಬೇಕು.
ಅದು ಆಡ್ ಮಾಡಿ ಮತ್ತೆ ನೀವು ಆಡ್ ಮಾಡಿರೋದ್ರಿಂದ ಸೇಮೇ ಬರುತ್ತೆ. 7,88,000 ಎನ್ಹಾನ್ಸ್ ಆಗುತ್ತೆ. ಈಗ 95,000 ನ ಮೈನಸ್ ಮಾಡಿದ್ರೆ ಆಸ್ ಅಗೇನೆಸ್ಟ್ 9,75,000 ಅಂತ ಹೇಳ್ತಿಲ್ಲ.
ಇವಾಗ ನೀವು ಆಲ್ರೆಡಿ ಯು ಮಸ್ಟ್ ಹಾವ್ ಪೇಡ್ ಅಲ್ಲ.
ಪೇಡ್.
So that 95,000 is not going to fetch any future interest.
No,
because you have already paid.
Paid.
So whatever enhancement is done for the injury case alone will fetch him interest
6%.
So that 1763 minus what you have already paid, he will be entitled for future interest at 6%.
6%. Enhanced compensation.
In view of the above, I pass the following order. Appeal is allowed in part.
Enhanced compensation would be 7,88,004.
Judgment and award is modified. Enhanced compensation.
Enhanced
7 lakh
88,004. That would be carries interest as well.
It is modified. Claimant would be entitled to enhanced compensation of rupees 7,88,004. You agree? Please agree. Along with interest at 6% per annum. Enhanced compensation shall be paid or deposited before the tribunal within 4 weeks from the date of receipt of copy of the order, along with the interest at 6%. Can be permitted to withdraw the entire amount.
I have no objection.
Yes.
They want, my lord.
Actually, that appellant is going to carry out his system, daughter's marriage. We want
The entire amount shall be released and dispersed in favor of the claimant upon proper identification. You want electronic transfer? By way of electronic transfer on the claimant furnishing relevant bank details. Registry to transmit the trial court records forthwith to the jurisdictional tribunal.
Serial number 52.
Yes, the records. The data is in the records.
Peka.
My lord, in that case, my lord, the Liberty General Insurance, I have take notice, my lord. I have collected the documents. Next week, any date, my lord, I will argue that matter.
Serial
2 months ಕೊಡಬೇಕಾಗ್ತದೆ ನೋಡಿದ್ವಿ.
Which serial number?
52.
36. I think my lord, not friend is mentioning 36.
All right. You want records?
ನಾನು ನೋಡ್ತೀನಿ ಒಂದ್ಸತಿ ನೋಡ್ಬಿಟ್ಟು 2 months ಕೊಡ್ಬೇಕಾಗ್ತದೆ. 1 lakh 1 lakh 2 lakh ಕೊಡ್ಬೇಕಾಗ್ತದೆ ಅಲ್ಲಿ.
ಅದು ನೋಡಿದ್ರ ಸಾಫ್ಟ್ವೇರ್ ಇಂಜಿನಿಯರ್
ನಾನು ಕ್ರಾಸ್ ಚೆಕ್ ಮಾಡಿದೆ. ಅವರು 2018 ಅಲ್ಲಿ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ. ಮಾರ್ಚ್ 2019 ತನಕ ತಗೊಂಡಿದ್ದಾರೆ ಸರ್. ಅವ್ರು 19 ಅಲ್ಲಿ ರಿಲೀವ್ ಆಗೋದು. ಆ ಪೀರಿಯಡ್ ಅಂದ್ರೆ 2 months ಕೊಡ್ಬೇಕಾಗ್ತದೆ.
7 months ಇಲ್ಲ ಅಂತಾರೆ.
ಇಲ್ಲ ಅವರು ಹೈಯರ್ಗೆ ಜಾಯ್ನ್ ಆಗಿರೋದು. ಅವರು ಹೈಯರ್ ಇನ್ಕಮ್ ಬಂತು.
ರೆಸಿಗ್ನೇಷನ್ ಅಕ್ಸೆಪ್ಟ್ ಆಗಿರೋದು ಮಾರ್ಚ್ ಅಲ್ಲಿ, ಬಟ್ ರೆಸಿಗ್ನೇಷನ್ ಕೊಟ್ಟಿರೋದು ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಕೊಟ್ಟಿರೋದು. ಅಕ್ಸೆಪ್ಟ್ ಆಗಿರೋದು ಮಾರ್ಚ್ ಅಲ್ಲಿ. ದೋ ಐ ಆಮ್ ಕ್ಲೈಮಿಂಗ್ 7 months, ಐ ಲೀವ್ ಇಟ್ ಟು ಯುವರ್ ಲಾರ್ಡ್.
ಬೇರೆ ಕಂಪ್ನಿ ಜಾಯ್ನ್ ಆಗಿರೋ ಸಮಯ ಹೈಯರ್ ಇನ್ಕಮ್
ಇಲ್ಲ, ಬೇರೆ ಕಂಪನಿ ಯಾವಾಗ ಜಾಯ್ನ್ ಆಗಿದ್ದಾರೆ, ಸ್ಯಾಲರಿ ಯಾವಾಗ ಬಂದಿದೆ?
ಅದ್ರದ್ದೇ ಇಲ್ಲ. ಅಪ್ ಟು
See what happens in the private sector.
Please, my lord. What is the loss during that period of my lordship?
December accident. In January, he has received December's payment. So January he'll be unemployed till he gets a fresh job. He may be sure if the bank statement he doesn't have any income by way of salary, that period will have to be paid. The next income which he has received from a fresh new company, that day will be the cutoff date.
What is the loss for that tax?
So from January, since January you have to give, because that amount which he has received in January is for the December.
Yes.
January, February, March, April, May, June. If he has joined in July, then till June you will have to pay. That you see the records.
Please ನೋಡ್ತೀನಿ ಸರ್.
Bank statement. For respondent number 2 seeks time relist on
9th 12th or 13th.
12th.
Serial number 52. Rangegoda Inna.
Ready. Second husband.
Ready. Yes, Mr. Rangegoda.
The case of injury, but the date of accident is 11/11/2019. The appellant has sustained fracture of femur. Age of the injured my lord 23 years. Avocation by not Pitter in Denso Kirloskar, earning my lord 20,000 per month. In paragraph issue number 2, my lord, paragraph 10 of the judgment, detailed discussion.
inpatient for a period of 6 days.
Inpatient for
6 days.
okay.
My lord, tribunal, my lord, after considering the evidence, consider the income of the injured, my lord, 9,500 instead of, my lord, 14,000. Date of accident is 11/11/2019.
9,000 ತಗೊಂಡಿದ್ದಾರಾ?
Please,
Should be taken.
14,000.
Hmm.
And my lord, doctor has assessed the disability, my lord, 42% to the lower limb, 14%
fracture of the neck.
neck of femur.
Neck of femur.
Please. 42% to the lower limb
Hmm.
and 14% to the whole body.
Hmm.
Tribunal, my lord, considered 8% instead of 4%, 14% whole body disability.
It is united as per the doctor evidence. So,
Then, my lord, pain and suffering 40,000 has been granted. Then attendance, food, nourishment charges, my lord, 1,800 has been granted. Medical expenses, my lord, actual 1,70,260 has been awarded.
Actual ಅಲ್ಲ?
Please. Then laid up period, my lord, only 19,000 has been given. 2 months.
28,000 to be given.
Loss of amenities, my lord,
In 2 months.
2 months 28,000 ಕೊಡ್ಬೇಕಾಗತ್ತೆ. 14,000.
Two months is enough to recover.
3 months.
ಫ್ರಾಕ್ಚರ್ ಇದೆ.
ಯುನೈಟ್ ಆಗಿರೋದ್ರಿಂದ
ಏನೇ ಮಾಡಿದ್ರು ಯುನೈಟ್ ಆಗಿದ್ರು ಇಟ್ ವಿಲ್ ಟೇಕ್ ಟೈಮ್.
Future medical expenses, my lord, doctor has stated in evidence around cost of another. He needs one more surgery.
What has the doctor said?
He said, my lord, around 60,000. Petitioner needs another surgery of the approximate cost of the surgery is around rupees 60,000.
Yes.
Loss of amenities, my lord, only 20,000 has been paid.
Earning capacity will increase.
Please.
Yes, sir.
ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಎನಿ ಕಾಸ್ಟ್ ಆಫ್ ಎಸ್ಟಿಮೇಷನ್ 60,000ಕ್ಕೆ. ಬಟ್ 60,000 ಹೇಳ್ತಾರೆ, ಬಟ್ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಎನಿ ಕಾಸ್ಟ್ ಆಫ್ ಎಸ್ಟಿಮೇಷನ್ ಅಂತ ನೆಕ್ಸ್ಟ್ ಇರಲಿ.
ಅದು ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸ್.
ಅಲ್ಲ, ಇದಕ್ಕೆ ಕಾಸ್ಟ್ ಆಫ್ ದ ಸರ್ಜರಿ 60,000 ಹೇಳಿದ್ರಲ್ಲ, ಅದಕ್ಕೆ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಎನಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. 14,000 ತಗೊಂಡು ಮಾಡ್ಬೋದು. This one is
15,000 income.
loss of earning capacity, income.
What about disability?
Disability, it is 12%.
1/3, my lord,
Because as per the chart,
42% lower limb.
as it is
1/3, my lord,
united,
14%.
12% can be taken.
What has the doctor said? It is united.
It is united, he said. Doctor said. 11. Yes. Admitted that the fractures are united and the petitioner can do his work with difficulties. In page 12, para 11, last lines. Right lower limb but 42% and to the whole body 14%. During cross-examination, PW2 admitted that the fractures are united and the petitioner can do his work with the difficulties.
With difficulties.
ಈಗ at present, next it will
Become all right. What is the age? 23 years.
23 years.
Fracture of femur.
Femur,
Depositionally closed traumatic right
But is there any
cervical fracture of
any
neck of
judgment which says
right femur,
the fractures are
fracture of
united?
the
Here, Ray, Mister, please. Discussing with him, we are arguing. Is there any judgment which says if the fractures are united, the disability opined by the doctor should be reduced?
united reduce normally. If it is small united, it is difficult. It is united, clear.
Right.
But slowly it will some limping ಆ ಥರದಲ್ಲಿ ಇರುತ್ತೆ, ಬಟ್ ಅದಕ್ಕಾಗಿ we are considering that one.
So what is your submission?
That is 12% can be taken as per our chart.
Normally, my lord, this court considered 15%, I think.
ಅಲ್ಲ ಸಾಕೆಟ್ ಅಂಡ್
Much
ಎಡ್ಜ್ ಆಫ್
of
ಫೀಮರ್
femur.
12%. ಫೀಮರ್ ಇಂಟ್ರೋಕ್ಯಾಂಟ್ರೈಟ್ ಕಾಂಡೈಲ್ ಇದ್ರೆ 12% ಇಂದ 15% ಅಂತ ಹೇಳುತ್ತೆ. ಬಟ್ ಇದು ಹೆಡ್ ಆಫ್ ಫೀಮರ್ ಇರೋದ್ರಿಂದ 12% can be taken.
Neck of the right femur. ಇದು ಕೊಡಿಮ್ಮ. Chart. ಇಲ್ಲ. Photograph of the femur ನೋಡೋಣ. Neck of the femur. Right femur shaft.
ಹಿಪ್ ಜಾಯಿಂಟ್ ಅಂಡ್ ಥೈ ಬೋನ್, ಸಾಕೆಟ್ ಅಂಡ್ ಹೆಡ್ ಆಫ್ ಫೀಮರ್.
Neck of the femur